whenever.
Yeah, I'm admitting you right now. There you are.
Okay,
Thank you.
you're welcome.
Appreciate it, Tim. Okay.
Okay, I'm just gonna run the restroom. Um, because I mean, you don't have the evidence for you to see what's before. the hearsay statements. I mean, it's a lot of case law.
Like what? There's no right to confrontation in the same. There's no right to confrontation in the same.
But for them to be properly found over, it has to be doing some legally misallowed.
So it would be legally admissible hearsay. That's my thing, is if they get deceased today, what's going to happen goes to trial. Please, then I'll just bring that to the charges against her.
Well, no, if we get found over and he pleads, part of the plea,
Really, he has to waive them today
well, then,
to get them dismissed as part of the plea.
because what you're going to do is when it gets found over, you're going to habitualize.
I can't habitualize him on the FIPFS second as a violent fourth. I can,
Right, and that's what you know, the bind over on the other, on the assault.
but the offer is FIPFS. So he would waive.
Are you guys ready?
2 through.
We have 2 minutes.
Yeah. Be aware, YouTube is on streaming live.
Let's go.
He's gonna get to this.
Ready?
Yes.
Why? You stand here. Make sure you get right away. Please rise. Report this court's now in session. Will Brian Oakley preside?
Got the defendant off the courtroom. Good afternoon, counsel. Oh, I think that prosecutor's better than she was last week.
Thanks, Judge.
You're not waddling yet. That was always my favorite stage, is when they started to waddle.
I am ready and on whenever you are.
Mr. Parker, have a seat next to your attorney, please. Appearances on the Parker matter.
Chair Hindling on behalf of the people, P 78685.
Ben Gonick on behalf of Mr. Parker.
All right, settle in, people.
I'm sorry, what did you say, Judge?
Settle in, make yourselves
okay.
comfortable. And I think I told you this last week. You guys, it's okay if attorneys jump to talk to me. It's okay if you stay seated. As long as Paula can hear you clearly, wherever you're at, it's fine with me.
Okay.
Same with the masks, on, off, whatever you're comfortable with. I think we've got lots of distance here. And Madam Prosecutor, are you ready for a witness?
Judge, could we have like 30 seconds? Yeah, right.
Do you want a private conversation?
That would be great, because if I could. Going.
Anybody in the,
We just need
Yeah,
to.
They can
Well,
go
you-
right back in
you
the.
can step in, yeah, you can step in the cell if you don't mind.
You didn't hear me, did you?
No.
When you went like that, I said, there, now I can see your handsome face.
Counsel, who's your first witness?
It would be Officer Griggs.
Griggs?
There's a
Thanks.
couple preliminary things I gotta put on the record.
Okay.
I can't see if that, yeah, it's on her. Can you point that mic towards you just a little bit, please? Just so I can be sure to pick you up.
I'll try to shout.
You do a good job. I mean, not shouting, but
What's she trying to tell
that I
me?
can hear you.
You're loud.
I noticed that you're one of the very few people that do not start out loud.
Oh, good, good.
That drives me insane.
My biggest criticism that I get is I usually talk too fast. So if I'm doing that, you can yell at me.
That you did do, that you did do.
A lot to say.
Angela Manarino does the same thing.
Oh, God. You can't cut her off.
Oh, she
I
knows
get her on the
better.
phone, I'm like,
But she talks so fast.
Yeah. She talks
But
very-
now in here, because I've caught her on it, and I will, she'll slow down.
It's like, take a breath. She does that just in general.
Pardon?
She does that just in general. when
I
she
know,
talks,
just
yeah.
talking in a conversation.
I suspect Angela doesn't do very many things slow. No, I mean, seriously, I mean, when she's walking in the building, she's on
Oh,
a
yeah,
mission, you know.
she's on a mission.
Enough time, council?
Yes, Judge.
Okay.
Prosecutor and I have been talking the past couple days, and we've tentatively worked out a resolution that we're going to put on the record in circuit court when it gets
You
found
need some
over.
time to talk to her?
No, we can put it on the record
Yeah.
now. Yeah, we're gonna accept your plea offer.
Okay.
Okay,
Okay,
okay. So she can put on the record what we're doing, and I'll either say yay or nay.
okay.
Okay, so at the outset, the people are not prepared to proceed today on count 1, criminal sexual conduct in the first degree. So I would ask that my intent was to dismiss that count and proceed to examination on the remaining counts. However, we did make an offer. The offer is for Mr. Parker to plead guilty to waive the remaining counts and then enter a plea at AOI at circuit court to felon in possession of a firearm. And then I would have to amend one of the felony firearm counts to comport or align with the FIP charge. I don't believe one was charged initially. So I would ask to amend the complaint to the extent that one of the felony firearm charges reflect that he was in possession of a firearm at the time he committed a felony of being a felon in possession of a firearm. So Mr. Parker at AOI would enter a guilty plea to felony firearm second and felon in possession of a firearm. And that's the plea offer. And then we would dismiss the remaining counts as part of that offer.
I just want to make sure I'm understanding correctly. That is accurate, but the CSC case would be dismissed with prejudice and not be redrawn. Is that correct?
Not dismissed with prejudice. I would dismiss it today, either way, prior to exam, because I can't go forward today. And I don't have an argument to proceed on that count today.
But I think, if I might, I think Mr. Gonick's concern is, there's no intention to refile on the count 1 if the plea gets taken at the AOI.
I can't make that promise as it relates to count 1. It
Okay,
would have to be a dismissal without prejudice.
okay. I don't know where that leaves us.
That's what I misunderstood then.
Okay,
Yeah, I just thought so.
okay,
We can
Mr.
proceed.
Gonick, can you speak up?
I'm sorry, we could proceed.
okay.
Okay. And then in that case, then I have to make an oral motion in limine as it relates to, so I would move to dismiss count 1, criminal sexual conduct in the first degree on the complaint at this point in time, because I cannot proceed on that count today. And don't have a legal argument to be able to proceed on that count.
Okay. One of my bench mates is calling me, which never happens, so give me just a second. Hello. Yep. Did you get over to talk to Rick Perry?
So are we gonna hold today?
Okay, if you're just getting there, you probably went to his shop. Yeah, they had 2 trucks there, because there was 2 of them there. He went back to his shop to get something. Call 941-1500, which is his office number, and hopefully somebody answers the phone. I'm just getting ready to start an exam. Okay, yep. Sorry about that. Go ahead, Counsel.
Thank you, Judge. So the second order of business is I would make an oral motion in limine an offer of proof as it relates to the testimony of Officer Griggs. The people would offer Officer Griggs's testimony. Officer Griggs spoke to the second complainant, Daniel Hopkins, when he first arrived at the scene on July 31st, 2020. Officer Griggs would testify that Mr. Hopkins told him about what had occurred that ultimately resulted in Mr. Hopkins stabbing Mr. Parker. The people believe that Mr. Hopkins' statements in this context to Officer Griggs would be admissible hearsay under 804 subparagraph 3 because Mr. Hopkins is not available. He has a privilege against testifying, and so that would fall under 804A1, I believe. And then secondarily, the secondary qualifying factor under the rule of evidence, that his statement would not only could subject himself to criminal liability, in fact did, as this court knows, Mr. Hopkins is bound over on assault with intent to murder charges as it relates to his actions with Mr. Parker. And so the people would offer Officer Griggs' testimony as it relates to what Mr. Hopkins told him to establish the counts, to establish the elements of the other charges under 804 subparagraph 3. And so that's my.
Okay, and Mr. Gonick, the first issue was, I'm assuming there's no objection to the dismissal of count one.
That's correct.
Okay, that's the second issue?
As to the second issue, Your Honor, preliminarily, I would point out the complainant here that they seek to offer the hearsay testimony from has not asserted that privilege. We don't know if that person will assert that privilege, and there's been no showing that the person's unavailable. The prosecutor can say it would probably be in his best interest to assert that privilege, but we simply don't know that. He's got to be the one that asserts that privilege. Secondly, I would point out that the statement in the discovery that was attributed to this so-called complainant was, when he was given the statement, he was trying to minimize his criminal culpability to make it nil, saying it was self-defense, defense of others, or that's the purported reason that he stabbed Mr. Parker, which one of the tests is the person trying to minimize their own culpability, which his statement, if you look at the video that I've reviewed and his written statement, that's what he's clearly doing. So those are two independent reasons why the complainant's statement in this case should not be admitted.
Any response from the people?
Yes, Judge. So I think it's clear that under, so 804 subparagraph A1 defines unavailability as is exempted by ruling of the court on the ground of the privilege from testifying concerning the subject matter, the declarant's statement. This court held a preliminary examination yesterday where Mr. Hopkins, or last week, sorry, is charged with serious counts and bound Mr. Hopkins over. It's readily apparent that I can't even call him to testify at this point in time because he has that privilege. He would assert his Fifth Amendment right not to testify.
Let me just stop you there.
Sure.
Because Mr. Gonick, I'm gonna paraphrase what you said. Correct me if I misstate your position. Mr. Gonick's position is you can't do that. Mr. Hopkins has to be here to say, I plead the Fifth.
Correct.
Okay, just respond to that issue.
Okay, I don't think that he has to be here to assert that privilege because the court could make the finding that he would under the rule of evidence that would allow for him to be declared unavailable.
Okay.
We know that he would assert that privilege as he sat here last week and chose not to say anything or not to testify, not to present any witnesses at his own examination. So I think.
Okay. And Mr. Gonick, I'm going to cut you off, counsel. Mr. Gonick, and you don't have to keep jumping up. I know it's instinctive. So it's okay.
Yeah.
What convince me? What case law is it that says that he's the only one that can assert the privilege?
That he's the only
He's
one.
actually got to be here to say, I plead the Fifth.
If you give me a moment, I'll give it to you.
That's sure.
Okay, yeah. If you give me a moment, I'll give
Sure.
I'll give it
Sure.
to you. Yeah.
I've never had this issue before, so educate me.
Ms. Angelini, will you please write down that statute number?
Oh, sure.
So I can make sure I get it correct.
Your Honor, all the cases that I'm reading indicates that when the witness asserts their Fifth Amendment privilege or whatever marital privilege or whatever the privilege may be, then they are unavailable. You know, here what we have is the prosecuting asserting the privilege for the potential witness. I mean, I think that's the position I'm taking.
Okay.
And again,
Go
my position is that under the wording of the rule, 804A1, unavailability as a witness includes situations in which the declarant, 1, is exempted by ruling of the court on the ground of privilege from testifying concerning the subject matter of the declarant's statement. I believe that this court can find and can rule that Mr. Hopkins is unavailable because he's pending charges, as this court knows, and the ruling from the court is what triggers the unavailability for purposes of MR 804.
Okay. I'm gonna allow the testimony to come in for this reason, because whichever way I decide, probably it's gonna be appealed at the circuit court. I think the most efficient use of resources is that we do it now. If I'm overruled on that issue, at least we've done what I had to do at my level. Because if I take Mr. Gonick's argument and circuit court overrules me, we're right back where we are right now, so we can have an exam. So I'm gonna allow the testimony so we can move forward today. Do either one of you want to put anything on the record?
Well, I would just, so we don't have, I don't need to have a continuing objection for the appellate.
Sure.
I would just have a continuing objection.
Sure, that's
So I don't
understood.
have to keep
That's
saying
understood.
no. And Judge, just to make things simple too, or to reduce the number of witnesses, we would stipulate to certainly a bind over on the felony firearm second and the felon in possession. I've reviewed the discovery and there's no getting around that.
Always love a good stipulation.
And I think that would take care of then, Sergeant Juris's testimony in its entirety. And Mr. Gonick, just to be clear for this record, you're stipulating to the defendant's ID as the person who possessed the gun at the gas station for the purposes of those
Correct.
counts. That would also take care of Officer Thompson's testimony, so I believe it would just be Officer Griggs and potentially Officer Daniels.
All right, so you want a minute so you can tell a couple other guys
Sure.
I can go?
Yeah, that'd be great. I
Can I run to
appreciate
the
that.
restroom in the meantime? That'd be great.
Thank you, Judge.
Yep.
What are we gonna do without our apples?
Come visit it.
We won't have any, compare it to how long they live.
Next year.
I know it's funny. Will they move it over there?
I'd like to move that one home.
Huh?
I'd like to move that one home. That's a pretty fertile apple tree.
It's very sturdy. I mean, come on.
I mean, it always has, I mean, every year it's got a pretty good crop on it.
Got tons of apples. That's like when we lived in my house. In our yard, there was a reindeer cherry. And we get.
Oh, yeah, yeah.
So I told Rick, I said, get some cheesecloth and put
Yeah.
on part of that tree for me.
Yep.
And he did. We got
Mhm.
quite a bit of the cut, so folks couldn't get it.
Right.
I got a lot of cherries, and they were the reindeer cherries.
Mhm.
Was not, hopeful.
Matter of fact, I wonder if there's still apples on that tree, if they finally fell off. I'm assuming the new buds may have pushed the old apples.
I think they all fell off. I didn't see any the other day.
I still have a tree in my yard.
You gotta play something noise.
My,
That was pretty good timing.
did, I just, they walked in together.
Yeah. Officer Griggs, come on up. Watch your step on the incline ramp. Raise your right hand, swear firm, tell the truth, the whole truth, nothing but the truth today.
Yes, sir.
Settle in. Have a seat. Your witness, counselor.
Thank you. Good afternoon, sir. Could you please state your name for the record?
My name's Officer Scott Griggs.
And how are you employed?
I'm employed by Van Buren Township Police Department,
How long have you been employed by the Van Buren Township Police Department?
19 years today.
Happy anniversary.
Thanks.
I want to direct your attention back to July 31st of 2020 in the early morning hours around 4:49 a.m. Were you working that day?
Yes, ma'am, it was.
Were you working by yourself or with a partner?
His own partner.
Okay, a zone partner?
Yes.
Okay, sorry. I thought you said zone or own. And were you driving a police vehicle
Yes, ma'am, it was.
and wearing a full police uniform?
Yes.
Okay. And at some point in time, did you receive a dispatch to 114 Estates Drive?
Yes, I did.
And is that in Van Buren Township?
Yes, it is.
Is that in the county of Wayne?
Yes, it is.
Okay, did you go to that location?
Eventually I got there, yes.
Okay, tell me what happened.
We were dispatched to a stabbing at that address at 114. The caller said that they would meet us at the Timberlands, which is just west of that location, in another mobile home,
About how far away?
less than a quarter of a mile.
And you weren't speaking, were you speaking directly to the caller?
I was not, I was dispatched.
And so you went to the Timberlands?
Correct.
Okay, what happened when you got there?
When I got there, we met a female, Miss Harrison, and another
Can I
subject.
stop you for a
Oh,
second?
sorry.
Yep, sorry. You said a female named Miss Harrison?
Yes.
Okay, what's her, do you know her first name?
Michelle, I believe.
Okay. And when you arrived, did she come to you or did you go to her?
We went to her.
Okay, tell me what happened.
My zone partner at the time, Officer Daniels, spoke to Ms. Harrison. I spoke to another subject that was there.
And who was that person?
That was Mr. Hopkins.
Did you become familiar with his first name?
I don't recall off the top of my head,
Would it refresh your recollection to review your report?
if I may.
Page 7 of 12. May I approach?
Yes.
I'm going to hand you a portion of your report, it's page 7 of 12, just for the record. Take a look at this. Don't say it out loud, but look up at me when you're done. Did that refresh your recollection?
Yes, it is.
And what was the person's first name?
Daniel,
Okay. And so did you speak to Mr. Hopkins?
I did.
Before you spoke to him, did you notice anything about him?
No,
Did you subsequently notice anything about him?
yes.
Okay. What did you notice about him later?
Later in the morning, I realized that he had some injuries upon his body, his
Where were-
hands.
Where were those injuries located?
Hands, his arms, fingers, and on the back of his head.
When you initially approached him and began speaking to him, what did he tell you?
He said he was in town, staying with his cousin, which was Miss Harrison, for a funeral. He was sleeping in the front room when Miss Harrison came home to her residence with a male. That male demanded money for driving her home from the gas station.
Did you later determine that male's name?
Yes, we did.
And what was that name?
Mr. Parker.
Objection, lack of foundation and hearsay.
I can.
Lay a foundation, go ahead.
After you spoke to Mr. Hopkins, was there additional investigation done?
Yes, there was additional investigation.
And was that additional investigation done in conjunction with the Canton Police Department?
Yes, it was.
And did you receive some information from the Canton Police Department that informed your investigation?
Yes.
Okay, and based on that information from the Canton Police Department, did that cause you to do something?
Yes.
And did that include making a police report?
Correct.
And in part of making that police report, did you use some of the information that you obtained from Canton police officers?
Yes, ma'am.
And did that include the name of the person that was investigated and that Mr. Hopkins referred to you?
Yes.
I would object this to leading as well, especially for the last question.
Sustain the leading.
So just,
Caution.
just for the record, under the court rules, I am allowed to lead to develop the witness's testimony. I think that there's also, I'm laying the foundation as Mr. Gonick objected and requested in order to be able to establish the ultimate
Continue.
question.
Continue.
So, okay, so the court is still sustaining Mr. Gonick's objection?
Yeah, just
Okay,
to whatever extent, be less leading.
okay. Did additional investigation take place after your conversation with Mr. Hopkins?
Yes.
Who did that investigation involve?
It was the Canton Police Department.
And was there communication between yourself and the Canton Police Department?
Yes. Well, via dispatch.
What was the nature of that communication?
Canton Police Department received a call of a male that was found at a gas station within a few miles of the incident that occurred. He was bleeding from the chest. And it seemed to be one and the same in regards to my subject who had left the park states.
I would object to the last comment. One and the same, I mean, there was
What's your objection?
a lack of personal knowledge.
He's testifying to his personal knowledge. Exactly his personal knowledge is based on his own investigation, continuing, and what he learned through the course of that investigation. It's exactly within his knowledge.
Allow it.
And was there any person, was the name of the person who was stabbed at the gas station revealed to you throughout the course of your investigation?
Yes,
And what was that person's name?
Mr. Parker.
Do you recall the first name?
I do not.
Would it refresh your recollection to refer to your report?
If I could, please.
I'm gonna show you again, for the record, page 7 of 12, Mr. Ronick. Please look at it, don't say it out loud, but look at me, and let me know if that refreshes your recollection.
Yes.
And what's that first name?
Kenneth.
Thank you. Now, because I got sidetracked, what did Mr. Hopkins tell you after he told you he was woken up by Miss Harrison and a mail? What else did he tell you?
Mr. Hopkins said that Mr. Parker asked him for money for driving Ms. Harrison back to her residence.
And what did Mr. Hopkins say he said to Mr. Parker?
He said he didn't have any money.
What happened next?
He said that Mr. Parker struck him in the head with a firearm and pointed it at him.
Did he tell you anything about the characteristics of that firearm?
He did not.
Did he tell you whether it was a long gun or a handgun?
He did not.
Do you remember writing a police report?
I do.
Do you recall whether you described the gun at all in your police report?
I must have, yes.
You recall describing the gun to
Yes,
some
I did.
degree in your police report?
Yes, I do.
Okay, what do you recall describing it as?
And I do recall it as a hand.
What else did Mr. Hopkins say happened after Mr. Parker struck him over the head with a gun?
He said he said that Mr. Parker and Ms. Harrison had a conversation, and he was asked about having sex, and then he was asked to stand in the kitchen and watch while Ms. Harrison and Mr. Parker had sex.
And just to be clear, what did Mr. Hopkins tell you the relative timing was that Mr. Parker said, or that Mr. Parker did as it relates to demanding the money and pulling out the gun?
I didn't get into specific time. I just assumed it was a sequence of events right after the question for money.
Okay, there was no gap in Mr. Hopkins' retelling of
Right.
this. Okay. And so what did Mr. Hopkins tell you happened next?
Mr. Hopkins said that Mr. Parker and Ms. Harrison had a conversation, as I said, and then they were going to have sex. Then he was asked to exit the residence.
Okay, and what happened after that?
So after he left his residence, after he left the residence, he went out to his car, which was just outside. He obtained a knife with a green handle on it, and was coming back up into the residence when.
I'm gonna stop you for
Yep.
a second. And I might have missed this, as he was outside, did Mr. Hopkins tell you whether or not he could hear what was happening in the trailer?
Yes, he said it sounded like Mr. Parker and Ms. Harrison were having sex.
Okay. And after arming himself with the knife, what did Mr. Hopkins tell you he did?
So he went back to the residence, and as he was about to make his way back inside the residence, Mr. Parker exited the residence.
And what did Mr. Hopkins tell you he did?
He said he stabbed Mr. Parker in the chest
Okay, did he tell you how many times he stabbed him in the chest?
one time.
And what did he tell you happened next?
He said Mr. Parker pushed him down the stairs, and entered his vehicle and fled the area.
When you say entered his vehicle, whose vehicle do you mean?
I'm sorry, Mr. Parker entered his own vehicle, Mr. Parker's vehicle.
Based on Mr. Hopkins' version of events, did you ask him anything?
I asked Mr. Hopkins if Mr. Parker was armed with a weapon of assault of any nature.
And what did Mr. Hopkins tell you?
He said no.
And you asked him if Mr. Parker was armed with anything when?
When he stabbed him.
Okay.
Excuse me.
And then what did Mr. Hopkins tell you he did with the knife?
Mr. Hopkins said he put the knife back in his vehicle.
At any point in time, did Mr. Hopkins tell you about anything else that Mr. Parker did with the gun?
No, he did not.
Do you recall writing a police report? Do you recall describing what Mr. Hopkins told you in the police report?
I recall parts of it.
Does that mean you don't recall other parts?
Correct.
Would it refresh your recollection to review your report?
If I could, please.
Again, approaching with page 7 of 12. Can you take a look at that? Tell me if that refreshes your recollection.
It does refresh my regulation, however, I don't,
Just,
okay.
you testified a bit ago that Mr. Hopkins told you that Mr. Parker pulled out a gun and struck him over the head with it.
Correct.
Did Mr. Hopkins tell you that Mr. Parker did anything else with the gun?
No,
Do you recall writing a police report, correct?
yes,
At the time you wrote the police report, would you say that you attempted to be as thorough as you could be under the time limits you had to write it?
yes,
And do you recall writing in your police report that Mr. Hopkins said Mr. Parker pulled out a handgun and struck him over the head with it when he would not give him the money and then pointed the gun at him?
I'm sorry, Counselor, I thought they meant after the stabbing, yes.
Okay,
Mr.
can you-
Hopkins,
So tell us about the misunderstanding then.
okay. As I perceived your question, there was an additional assault with the gun after the stabbing.
Fair enough.
Mr. Hopkins said that after he was struck in the head in the mobile home, after he was struck in the head, then Mr. Parker pointed the gun at him.
Okay, and that's what's reflected in your report.
My apologies.
That's okay. It's my fault. After you spoke to Mr. Hopkins, what did you do next?
Mr. Hopkins told me that he had the knife in his vehicle. I received permission to search his vehicle.
From whom did you receive that permission?
From Mr. Hopkins, gave me permission to search his vehicle.
Okay.
I located the knife in the center console. It was about a 5-inch knife with a green handle and a black sheath.
What did you do after that?
Took some pictures of the knife where it was located at. I secured that knife in my patrol car.
Did you ever speak to Michelle Harrison?
I did.
Okay. Where did you speak with her?
Just right at the scene there at the Timberlands where we all kind of met up.
Okay. And just to be clear, Mr. Hopkins, did he describe the things that you just told us about as happening at the Timberlands or at the original dispatch
At the
location?
original dispatch location.
And what was the original dispatch location?
114 States Drive.
Okay. And did there come a point in time where you talked with Ms. Harrison about what had happened to some degree?
To some degree, yes.
Okay, did you have her fill out a written statement?
I did.
Okay, did that involve you asking her questions and her writing things down and you writing things down?
Yes.
When you were talking to her, what was her demeanor like?
She seemed relatively calm. I believe she was intoxicated. I can't recall exactly.
Why do you believe she was intoxicated?
Just based on time of the call during the morning, I should say. And at the
I
time.
don't want you to, I'm gonna
Okay.
stop you there.
Yeah.
Based on her demeanor at the time, aside from the time of the call, what other reason did you have to believe she may have been intoxicated?
If I recall correctly, I believe she had some intoxicating odors coming from her purse, and I smelled some alcohol in her breath.
Okay. And do you recall what time it was that you spoke with her and took that statement?
I do not recall the exact time.
Would that be reflected this was a written statement, correct?
Yes, ma'am.
And would that time be reflected on the written statement?
It should be, yes.
Would that refresh your recollection if you referred to that?
Yes, it would.
George,
Sure.
please take a look at this. Tell me if your refreshes your recollection as to the time that you were speaking to Ms. Harrison.
Yes, it does.
Okay, and what time was that?
5:07 a.m.
Okay, and what time was the original dispatch?
4:49, I believe.
Okay.
Yeah.
Okay, and so Judge, at this point, anticipating the objection from Mr. Gonick, I would move to proceed under MRE 803. I want to get the right number because I always get them messed up. To an excited utterance, a statement relating to a startling event or condition made while the declarant was under the stress of the excitement caused by the event or condition. The dispatch was received, and they were dispatched at 4:49 a.m. This officer, Officer Griggs, is talking to Ms. Harrison at 5:02 a.m. shortly after the initial call. The stress of the excitement was still certainly ongoing and related to the attempted robbery that Mr. Hopkins talked about, as well as the stabbing that took place, both exciting events.
Judge, I would object to the statement. The officer clearly testified when he was asked about this woman's demeanor. He said she was calm. I mean, in fact, the video relates her speaking in the same conversation that I'm speaking right now, and this officer was testifying. There wasn't anything excited about her voice. I mean, there was, he hasn't, I don't think, I guess what I'm trying to say that I'm not saying is the proper foundation hasn't been laid. There's nothing to indicate she was yelling, screaming, or anything like that.
And again, the wording of the rule, everybody expresses excitement or the excitement of an event differently. The wording of the court rule doesn't require screaming or hysterics. I would also ask to proceed under 803 subparagraph 1, present sense impression, as again, the stabbing had just occurred and she's just describing immediately after to him, explaining the event that had occurred shortly after, again, immediately after perceiving the event.
So I haven't heard anything that makes me think it was an excited utterance, so let's talk about present sense impression.
I'm sorry, I didn't hear the whole the foundation for that.
Go ahead, counsel.
So I would ask to proceed under present sense impression, because the next question that I ask him is going to call for hearsay. It's what she told him. So I can do that and then revisit the objection, but thinking ahead, I'm asking to proceed under present sense impression, which, according to MRE 803.1, is a statement describing or explaining an event or condition made while the declarant was perceiving the event or condition or immediately thereafter. This is immediately after this event occurred that Ms. Harrison is telling Officer Griggs about what had occurred. And she's describing that event as required by, or as stated in the rule of evidence. So I'm asking to proceed under 803 subparagraph 1.
Mr. Connick?
Well, I would object because I don't think the proper foundation has been laid, because I don't think we know when this occurred and what immediate means.
I think the testimony is clear that it's roughly 12, 15 minutes after the dispatch call, but that's the only testimony that's been placed on the record today. So I agree with Mr. Gonick. There's not a proper foundation to get present sense in.
I can attempt to lay a better foundation, and
Sure,
if I
go
feel
ahead.
it, then I'll go that direction again.
Jeff, take a run at it.
Okay. Officer Griggs, are you aware of how long after the 911 call was made that you were dispatched to the location?
I would imagine it was,
I don't want you to tell me
Yeah.
what you would imagine. I want you to tell me, are you aware? Do you know how long?
I don't know specifically the exact time. When someone calls 911, we go immediately after.
Okay, so on July 31st, 2020, you would have been dispatched immediately after the 911 call that you previously testified about.
Yes, ma'am.
And when you got there, you spoke to Mr. Hopkins, who eventually admitted, or who eventually told you about what happened and admitted to stabbing Mr. Parker.
That's right.
And did he tell you about when this occurred?
He said it was with, I don't recall exactly what he said in regards to the time frame. No, he did not.
Okay, did he tell you whether or not he had just called 911? Or let me go back up. Did Mr. Hopkins tell you that he was the 911 caller?
He did not.
Okay. Did you become aware that Mr. Hopkins was the 911 caller?
I did not know.
Okay. Okay. Did the dispatcher tell you what the nature of the dispatch was?
A stabbing.
Did you write in your police report what the nature of the dispatch was?
Yes, I did.
And as you sit here today, you don't recall writing that?
I don't recall exactly what I wrote in regards to what it was dispatched at.
All right.
Off the top of my head.
If I showed you your report again, that
Yes,
refresh your
I will.
recollection.
Sorry.
Just to be clear, did you review your report prior to testifying today?
I did.
Okay, I'm gonna approach, if it's okay with the court, with
Sure.
page 6 of 12. Tell me if this refreshes your recollection.
It does.
What was the exact nature of the dispatch?
Objection, hearsay.
Its effect on listener. Based on what the dispatcher told him, this officer did something. He's already testified about that.
Just to clarify, for clarification, Mr. Gonick, you're objecting to Ms. Officer Griggs testifying as to what dispatch told him on the dispatch run, or the dispatch call?
Yes.
Overruled.
What was the nature of the dispatch?
Dispatched a male that had been stabbed in the chest.
Did the dispatcher tell you about the nature of the 911 caller?
They did not.
Officer Griggs, do you recall writing a police report?
Yes, I do.
Okay.
Counselor.
In your police report, do you recall writing, the caller said someone pulled a gun on him and he stabbed him in the chest?
Yes, I do.
Is that what dispatch told you?
Yes.
And it's your testimony that you would have been dispatched immediately after the 911 call?
Yes.
We're back at, I would ask to proceed under MRE 803 subparagraph 1, present sense impression, as it relates to the statement that this officer took from Michelle Harrison.
Mr. Gonick.
I would still object because there's no indication when the event occurred that triggered the calling. If it occurred an hour earlier, 2 hours, or 5 hours earlier.
Agreed.
And just for the record, my response would be that the exciting event, or the event that had just occurred, was the 911 call and the reason for the 911 call. And so the witness is describing why 911 was called about 15 minutes after 911 was called.
So the exciting event is the call itself.
The present sense impression would be describing the event that triggered the 911 call, which was about 15 minutes prior to her describing it.
Yeah, but the exciting event is the actual stabbing. And there's
Correct.
been no testimony as to when that stabbing took place. So if I'm gonna go present sense from the stabbing, I have to know when the stabbing was.
And then the stabbing was the reason for the 911 call. So the
Which
911 call,
that doesn't help me.
okay. I don't think I have anything else.
Your witness.
Yeah, I just have a few questions.
Yes, sir.
Officer, you spoke with Mr. Hopkins, true?
True.
You weren't present when whatever happened at that home happened, correct?
That's correct.
Did you meet them at where Mr. Hopkins was staying at that home?
I did not meet them there.
Okay. In fact, it was some distance away,
Yes,
correct?
sir.
About a quarter of a mile, if I heard you correctly?
Yes, sir.
Okay. Now, Mr. Hopkins told you that Mr. Parker was demanding money for bringing the woman home, correct?
Correct.
Okay, I'm gonna object. I believe Mr. Gonick's testimony was Mr. Parker told you. Is that right?
I thought I said Mr. Hopkins, but if I didn't, I misspoke.
Okay.
I'll rephrase the question.
Just so we're all clear.
Mr. Hopkins told you that Mr. Parker demanded money for bringing the woman home, correct?
Correct.
In fact, there's nothing Mr. Parker or Mr. Hopkins, did Mr. Hopkins tell you that he pulled out a gun demanding money?
No.
Okay. In fact, after Mr. Hopkins told you after Mr. Parker demanded money from Mr. Hopkins, and Mr. Hopkins said, I didn't have any, Mr. Parker hit him in the head with a gun, correct?
Correct.
Okay. And he didn't ask him for any more property or anything like that, correct?
Correct.
Okay. That's all I have.
Redirect.
I don't have anything else.
Okay. Officer Griggs, you can step down.
Thanks, sir.
Are you okay?
Yeah, oh, just back.
Okay.
Yeah.
I always make sure everybody's okay.
I appreciate it.
I don't have any other witnesses.
I'm assuming no witnesses from the defense.
That's correct.
All right, arguments.
Judge, I would, let me get my information out.
Sure.
I have an argument as it relates to count 2 and count 5. I agree that there is not enough evidence to proceed today on counts 3, 4, and 6. So I would ask that those be dismissed without prejudice, as with count 1, criminal sexual conduct in the first degree. Count 7 is a misdemeanor, therefore defendant's not entitled to exam. Count 8 is the felony firearm count associated with criminal sexual conduct in the first degree, so I agree that that count should also be dismissed without prejudice.
I'm sorry, counsel, what count was that?
8.
So let's from the top.
Yep.
You want to dismiss 1, 3, 4, 5, 6, or not 5, 4, right? 1, 3,
1.
4, 6, and 8.
Yes. And then.
Go ahead.
Count 9, I would have the same argument that I'll eventually make for count 2. And count 10 can remain as the felony firearm count that I would make the argument for bind over on count 5. Count 11, I believe, would have to be dismissed without prejudice as well. Count 12 as well. Count 13 is the count that we previously discussed today, that I would move to amend the charging instructions that the defendant did carry or have in his possession a firearm, to wit a handgun, at the time he committed or attempted to commit felony, to wit felon in possession of a firearm.
There's no objection to that amendment.
I just don't want to lose,
Yep.
because we didn't say anything about 14.
Yep, so count 14 is stipulated as to the bind over by defense, and so count 13 would be the felony firearm count that travels with the felon in possession of a firearm, both of which Mr. Gonick agreed there would be sufficient evidence to bind over.
I'm sorry, it was 14 and which two counts
14 and 13 go together,
were stipulated? Right,
but I have to
but
move to
13 is
amend.
it's an amended 13 and
Correct.
14 were stipulated too.
Correct.
All right, so the argument is going to be on 2, 5, 9, and 10. People move to dismiss 1, 3, 4, 6, 8, 11, and 12. We're all on the same page, I hope, Mr. Gunner?
Correct.
Okay, let's talk about argument then.
Okay, as it relates to assault with intent to rob while armed, in order to bind that count over, the people have to show that there was an assault, the defendant assaulted the complainant, in this case it would be Mr. Hopkins. Second, that at the time of the assault, the defendant was armed with a weapon. And third, that at the time the defendant intended to commit a robbery. Importantly, the crime does not have to be completed, and defendant, even at trial, the crime did not have to be completed, and defendant did not have to actually take any money or property, just at the time he intended to commit the robbery. The testimony from Officer Griggs about what Mr. Hopkins said that the court allowed pursuant to 804 subparagraph 3 establishes the elements to that charge, that the defendant was upset with Miss Harrison, and they got into an argument about the money, then the defendant demanded money from Mr. Hopkins. When Mr. Hopkins didn't produce the money, he hit him over the head with a gun. And then Mr. Hopkins also said that the defendant pointed the gun at Mr. Hopkins. As I'm saying that, I think count 6 would also be, there's also sufficient evidence for count 6. So it would be 2 separate felonious assaults, one for physically hitting Mr. Hopkins over the head, and the second for pointing the gun at him. And those elements are established by Officer Griggs' testimony as well. Officer Griggs testified, Mr. Hopkins said that the defendant had a gun and committed the crimes with the gun. Mr. Gonick stipulated and agrees that Mr. Parker was the one possessing the gun at the gas station. Officer Griggs testified about the concurrent investigation and Canton discovering the man who was stabbed at the gas station, who was the one that possessed the gun. So based on Officer Griggs' testimony, I believe that people have established, at least to a probable cause standard, the elements of each of those crimes charged. I apologize for saying I would dismiss count 6. I think that based on the 2 separate acts of hitting him over the head and pointing it, there's sufficient evidence for 2 felonious assaults and 2 felony firearm seconds as it relates to each of those felonious assault charges.
Your turn, Mr. Young.
Judge, initially, I think that the bind over would only be proper on felony possession and felony firearm
Sir, I
second.
can't hear you. Sorry.
I'm sorry, I got these new hearing aids and my voice is like real loud here, but it's not coming out loud here. In any event, I would object to the bind over on all the charges except felon in possession and felony firearm for the reasons I stated earlier, the inadmissible hearsay, or what we contend is inadmissible hearsay. I'm not going to belabor that. I think I preserved it for the record, and I'll move on from there. In terms of the felonious assaults, Your Honor, I believe that is a question of fact. If you're going to allow the hearsay statements that you indicated you were going to allow. The charge that I'm going to quarrel with, that I don't think that there's been sufficient evidence in this record with, is the assault with intent to rob while armed. The officer testified, I think, quite candidly, truthfully about what he recalled and specifically what Mr. Hopkins told him. Mr. Hopkins indicated that my client brought the woman home to where she was staying, wanted money for gas and was demanding money from gas and started demanding money from him. And when he said he didn't have any money, according to Mr. Hopkins, my client pulls out a gun and smacks him in the head with it and then points the gun at it. But there's never a statement attributed to Mr. Hopkins after that while he's pointing the gun or has the gun out and hits him in the head, you better give me some money or else, or anything of that nature. I think the demanding of the money isn't a crime, but what transpired afterwards could be a question of fact for an FA. I just don't think the evidence is sufficient to support the assault with intent to rob while armed. And for that reason, we would ask for a dismissal on that count.
Ms. Ehrlich,
Just to briefly respond,
please.
even at trial, even to beyond a reasonable doubt standard, the defendant's intent to do an act can be shown by a number of things, and even minimal circumstantial evidence will serve to prove that, especially at exam, like in this case. The fact that the defendant is demanding money from Ms. Harrison next to Mr. Hopkins and then asks Mr. Hopkins for the money, and when he says he can't produce it, hits him over the head with it, and then continues to engage in the argument. Eventually, Mr. Hopkins told Officer Griggs that there was the discussion about defendant demanding sex as repayment instead of the money Mr. Hopkins is sent outside. I think that establishes to a probable cause standard defendant's intent to rob Mr. Hopkins at the time he was demanding the money and hitting him over the head with the gun. Regardless, if he's demanding the money from Mr. Hopkins at the time that he has a gun on him and out, you can still infer defendant's intent to rob Mr. Hopkins of the money based on his actions, his demand for the money, the fact that he had the gun, the fact that once the money wasn't produced, he hit Mr. Hopkins over the head. I think that that's sufficient to a probable cause standard.
Judge,
Go ahead. Yeah, go ahead.
if there was testimony in this record that while Mr. Parker was demanding money from Mr. Hopkins, or Mr. Hopkins said while he was demanding money, he saw a gun, observed a gun, saw Mr. Parker with a gun, holding it in a threatening manner, I wouldn't have an argument. I mean, because there would be circumstances, but there's no testimony in this record that Mr. Hopkins even observed a gun prior to Mr. Hopkins stating, I don't have any money, I can't give you any. And then the next thing is, according to Mr. Hopkins, my client then pulls out a gun, and he was mad and he hits him in the head and points a gun at him. But there's no testimony that after he pointed the gun at him or hit him in the head said, you better give me some money or anything like that.
Anything else?
That's it.
Madam Prosecutor, anything else?
I don't think it has to be in that exact sequence of events, just like with a larceny, it can be in the course of just like a regular armed robbery. It can be in the course of committing a larceny, which is an attempt, which could be things before, during, or after. So everything that Mr. Parker did in the course of what happened inside that trailer, in the course of trying to get that money, this court can use to infer his intent to rob Mr. Hopkins. And so that's what I would rely on.
I agree. All right, I'm gonna bind over on, I just wanna make sure we're all on the same page again. Count 2, 5, and 6, 9 and 10. And then 13 and 14, I'm gonna bind over because that was stipulated to, and we're gonna clarify exactly what the amendment is on 13. Remaining cases will be dismissed.
There should also be count 11 then, the felony firearm that relates to the second FA.
Oh, yeah, 11 tags with 6.
Yes.
Got it. All right, Mr. Gonick, are we clear on our numbers?
Yes.
All right,
And based on that, just so that the record is clear, and I had talked to Mr. Gonick about this at the last exam date, depending on what the court found over on, I have to check the statute, but I believe that I would be amending the information, aside from all those things that we've discussed today, as it relates to the habitual offender fourth offense notice. I believe that because the court has found over on assault with intent to rob while armed, that defendant may be a violent habitual fourth offender with a 25-year minimum mandatory. I'll confirm that and communicate with Mr. Gonick about whether that amendment will be reflected. It is just a notice provision, so I will follow up with Mr. Gonick as it relates to that.
okay. And counsel, the amendment to count 13,
Yes.
let's get that clear on the record.
Yes.
Exactly what is the amendment?
So the amendment is actually to the instructions. The PAC code remains the same. So it would still be count 13,
Okay.
felony firearm.
Then I don't care then. Well, I shouldn't say that.
Yep,
The PAT code doesn't change, then the clerks are
Correct.
okay. That's my
Correct.
main concern.
Yep.
Okay.
it would still, just for the record, be 750.227B-A.
Okay. All right. Bind over sheet. All right. So AOI date will be, should be the 22nd at 9 a.m. Anything else?
I'm sorry, what day, Jeff?
Oh, he's in custody 1 week, next week.
Yeah.
So it should be the 15th. Thank you. Anything else, folks?
Not from the people, thank you.
All right, Mr. Parker, good luck downtown.
You want to close out Zoom?
I will.
When do you do, counsel? Ms. Hindeling?
Yes.
So when do you do?
I'm sorry.
When do you do?
Oh, June 19th. So we'll see. Hopefully.
I have an 8-day-old granddaughter, so.
Oh, congratulations. Is it your first?
No, I have a grandson. He's 19 months.
Oh, wow.
They're
You're gonna
real
be
close.
busy.
They're brother and sisters.
Oh, that's good. My boys, I have 2 currently, and they're like at each other's throats constantly. So this is gonna be super enjoyable.
Oh, you're having a girl?
No,
Oh,
it's a third boy. It was sarcasm. They're gonna be, it's bad. The little one, so he'll be the middle, is like my Klingon. The older one The older one and the middle one love each other,
Mhm.
but they're like always, they're gonna be like on each other and pushing and like playing like that, so,
As bad as they fight twice as hard for you.
yeah, I hope so. So, it'll be good. Having brothers is a special thing.